Hi, thank you for joining me today to talk about biometrics and privacy. Is it time to face off, or is that FaceApp? In mid-2019, as you may recall, it wasn't that long ago, FaceApp became headline news with a huge concern around security. At the time, it was alleged that FaceApp was actually taking not only the photos that you chose to upload, but also taking photos that were in your photo gallery, on your camera, on your phone, that they were taking those photos, they were uploading them to the cloud, they were then transferring those photos across to Russia, ostensibly to create some sort of giant facial recognition database that then Russian authorities would be able to use. This all was headline news, and at the time, FaceApp actually responded and they said, well, yeah, we do actually take photos that you upload and we do have to put them into the cloud because we need that processing power in order to show you what you're going to look like in 50 years' time. And so they then went on to say that unless you're a user based in Russia, they weren't transferring your data through to Russia, even though their developers and their R&D team were Russian. They showed their Amazon Web Services locations, they showed where their data centers were. And they also confirmed that after 48 hours, they were deleting the photos. So really, ultimately, aside from the fact that they were a Russian company, a lot of the allegations weren't entirely weren't founded, and that they weren't using these photos for the nefarious purposes for which people were thinking that they were. And it got me thinking, how often are we sharing personal information and biometric data? Our facial recognition is biometric data. How often are we sharing that information? Who are we sharing it with? How are we inadvertently disclosing that information? And then if I have done that, what can I as an individual do to keep control of my biometric data? It's valuable data to me. So that's what prompted me to do this talk and to think about it. And obviously since then, COVID has also come along. So before we delve into this topic, I just wanted to say, who I am. So my name is Melissa Wingard. I'm special counsel at Phillips Ormond Fitzpatrick, and we are a specialised intellectual property firm. I personally have been a lawyer for over 15 years. I specialise in information technology law, cybersecurity, privacy. I remember when I was a junior lawyer, baby lawyer, privacy wasn't a thing. It's been one of the things that has been so great about technology is not only the convenience, but we've really started to look at privacy, and privacy is coming to the forefront. I remember, when I did start out, I had a general counsel who once said to me, not to worry about the privacy laws because there was no penalties associated with them. But obviously, look at what the GDPR has brought in, notifiable data breaches. So, privacy it's a really important area of law, and it's something I think we as individuals all are incumbent to be responsible for. So, I've also worked across Asia Pacific for a number of different organizations. I've had head of legal roles for Asia Pacific, so I've worked extensively in Singapore, Malaysia, Indonesia, India, China, and I care a lot about educating people as to their rights to privacy. It's a fundamental human right, and we should be cherishing it, and we should be knowing and understanding what we as individuals can do. We can't fix everything, but we can certainly take control over our own biometric data. Because don't forget, your personal information and your biometric data is yours. It may not always be in your control, but it is still yours. And I think we really need to start thinking about what are we exchanging in return for giving such a lot of ourselves to organizations. So let's start at the beginning. Biometric data. Well, what is it? So it's more than just fingerprints. I know we're all, we think of fingerprints, we've got our phones. Everything's got fingerprint data these days. We've all watched Mission Impossible, iris scans, retina scans. So biometric data falls into two basic kind of buckets, really. It's physiological, which comprises of morphological and biological. And then there's also behavioral. So these are those characteristics of an individual which are distinguishing repeatable biometric features and which can be extracted for the purposes of biometric recognition. So it's more than just your fingerprint, it's more than just your face. It can also include your DNA, it can include what you smell like, it can include the shape of your ear. Apparently that's unique to us. It also looks at gait and walking style. That can also be biometric data. Vein recognition. I mean, some of these are amazing. You don't even think about it. But and even your keystroke dynamics. So how you type, the way that you type, that can be biometric data. So when we start to talk about it, I think we need to think more than just fingerprints, facial recognition, although they're obviously the key ones. And I suppose the reason they come about is because they're the ones that can be used by government, law enforcement, to recognize us, and they're the ones that are often bringing out the privacy concerns at the moment, because you're finding law enforcement, scanning crowds, using facial recognition technology in order to identify people. So why should we care about this? Biometric data and privacy. And I think this, in a way, this talk has become even more important since the start of the year. We've had COVID. We've had a coronavirus. This whole novel coronavirus has completely upended our lives at the moment. I mean, we were supposed to be doing this face-to-face in Singapore 6 months ago, and now you've got a video of me. But what it's also shown is that we're going to be moving rapidly, absolutely rapidly, towards a touchless technology and contactless pathways. We're seeking to find a way to navigate in day-to-day life that doesn't actually have us exposed to coronavirus. So, how do we access our offices without touching lifts or without swiping cards? So there's a real push and a real acceleration towards the use of biometrics that I think we need to be aware that whilst they're looking to solve a public health issue, the law needs to keep up with that. And we also need, as individuals, to kind of balance the sharing of our information as well. So when you start looking at the privacy laws, there are some privacy laws that do speak directly to the concept that biometric data should be treated as sensitive data, but not all laws are to that stage yet. And I guess one of the things that's concerning is because you've got technology and government's use of that technology really outpacing the legislation. And we rely, as individuals, we rely very heavily on that legislation to provide us with our rights, because without the legislation and the framework within which to operate, we're left with, taking personal legal action. And often that isn't, there's such an imbalance between the individual and the organisation, or the individual and the government, that's not an avenue many of us have. We don't have the time, we don't have the money, possibly not even the inclination to do that. So I think this is really front of mind at the moment, as I said, because we're moving towards this touchless tech. There's, just as a slight aside, there's a really interesting animation on the BBC at the moment about what life might look like in 2025. And it shows a world where, navigating from home into our offices is a completely contactless pathway. So again, overlaying what that future looks like with the technology that's required, and then the information that those organizations are going to have about us, this is a topic we really need to be concerned about, and we need to care about it. Because our biometrics are inherently identifiable, and they're us. Our biometrics are us. My face is me, as much as some days I'd like to change it. It's not going to change that easily. And the issue with this inherently identifiable aspect of it is that a lot of our privacy laws, even the gold standard GDPR, relies very, very heavily on this concept of anonymization. So once personal information is anonymized, organizations are free to deal with it how they want to deal with it. Now, my issue with that is that I don't believe there is a way to fully anonymize biometric data. It's always inherently identifiable information. And even these days, there's a school of thought that says, well, with quantum computing, is there a way to actually anonymize any kind of data? You might pull it apart, but then computers are smart enough to put it all back together and potentially make it, re-identifiable information. So I think there's some real issues that need to be navigated around that. And I suppose the fundamental issue for us as individuals too is, there's the use of biometrics for the purpose of identity, and there's the use of biometrics for the purposes of authentication. Now, identity is one thing. If we're using it for the purposes of authentication, that's an area we really need to be thinking quite closely about, because once our passwords are leaked, we can change our password. You go into Have I Been Pwned and you see whether you've actually had either had your password or your email account has been hacked, and you can change your email account, you can change your password, you can use a password manager. Like you can put controls in place to protect all of that. If you're using a fingerprint or a face or an iris or a retina or the shape of your ear to authenticate who you are, and that information becomes public, how do you then get it back? You can't. So whilst today's talk is looking more at what you as an individual can do in terms of controlling your biometric data and what people can do with it, what organizations can do with it, and what the frameworks are within which you can, seek to navigate that world, I think there are there's a lot of other issues that really need to be considered about how biometrics are used and how we keep our law keeping pace with it. So what I just quickly want to do now is go through, and look, this is quite a short talk, so it's not going to be in incredible detail, but I just want to have a high level look at a couple of comparative jurisdictions to see what some of the countries that are known for using biometric data significantly, what laws are in place in those particular jurisdictions. And obviously, because we're at Black Hat Asia, we're looking at Singapore, China, and India. So as I said, it's only going to be at a high level. Don't have a lot of time to delve into the details, but we can obviously do that at another time, or if you want to reach out to me. And the reason I thought it would be useful to have a look at these three, and what we'll come to at the end is some action items or some things that you can do as an individual. But I guess the fundamental or underpinning of all of this is the laws do change from region to region. We kind of all know that. I think there is an expectation these days that because there's been so much media and press about GDPR, that GDPR applies across the board. It doesn't. So I think as an individual, it's kind of key for us to just at a very base understanding know what country are these people operating in. So, I'm sitting in Australia at the moment, but if I download an app on my phone and I'm giving them some information, where are they based? They could be based in Singapore, they could be based in the USA, could be anywhere in the world. So just knowing that jurisdiction and some of those differences, I think, is a really important thing for us as individuals to do. And I think we also need to recognize as well that there are vast differences between the laws that apply to governments when they collect your personal information and your biometric data, when private organizations do it, and also when your employer does it. So we have a few different buckets of people, per se, that are collecting and using the information, and the laws don't apply consistently across all of them. So Singapore is actually... So Singapore has quite a number of pieces of legislation, but thankfully they're all in the same space. So Singapore has the Personal Data Protection Act, and that is the legislation which covers how private organizations can collect your information, use your information, disclose it, store it. So obviously the PDPA puts restrictions on organizations as to what's required for consent, how long they can keep your information for after they no longer need to use it. So all of the normal things that you think about when you think about privacy laws. The PDPA also does specifically note that biometric data is personal data. It calls out faces or facial recognition, fingerprints, DNA, and there are a number of avenues for redress under the PDPA for individuals if you think an organization is using your information, or you just want to find out how they're using it, or you think it might be wrong. So there are avenues to, contact the organization that has your information, ask for corrections, find out how have they used it in accordance with what they said they were going to use it for. At this point, I'd just like to note there's no right to erasure in Singapore, so you can ask for correction, but you can't ask for them to erase your information, which isn't necessarily all that helpful. But the right to erasure is, I actually think, a very important, or the right to be forgotten is a very important, I think, aspect of privacy law. I think us as individuals need to have the right to be able to say to an organisation or to, someone using our biometric data, I no longer consent to you having that, please delete it permanently. However, it's really it's a concept that's come out more of the European Union, so it's enshrined in the GDPR, and as we'll see, India's looking at it as part of their new bill, but not all countries have that right. So Australia doesn't either. You have the right to ask for a copy of your information. You have the right to ask for it to be corrected, but not necessarily for deletion. And sometimes it's the deletion that you want. So if you've if you've gone to the organisation and you haven't gotten any kind of remedy that you're happy with, there is in Singapore the Personal Data Protection Commissioner. So that is an avenue for, interestingly, both private sector organisations and government agencies or public agencies. So this is where we're talking about this divergence between, the law for organisations and the law for governments. Singapore kindly has this all set out quite clearly. Well, as clear as you can in some respects. So public agencies themselves are not governed by the PDPA. They actually are governed by another piece of legislation called the Public Sector Governance Act. And under this act, what it says is public agencies need to comply with the minister's directions around data protection. So the minister will hand down data protection regulations, and it's up to the public agencies to implement those. So, and when we're talking public agencies, we're also talking things like the Singaporean Immigration and Checkpoint Authority. So when you get your fingerprint scanned, or I wish I'd gotten my fingerprint scanned to go into the conference, those sorts of public agencies collecting that biometric data. So they've got a separate set of rules that they need to comply with. And there's a curious thing in Singapore, well, I find it kind of curious, in that if a public sector agency is found to have breached their obligations in relation to protecting your personal information, your biometric data, it's not actually the public agency that gets in trouble for that. It's actually the official, the public official, who is responsible for the breach that actually is liable personally and individually for that breach of privacy. So given the fact that data moves throughout so many people, it's not clear to me on the face of it how that's actually going to apply in practice. But it is still a remedy though, and it has the benefit of being an individual. I guess it becomes an individual sanction. So I suppose the thinking and the hope is that then those individuals working within those public agencies will actually hold the information more carefully and manage it more closely than perhaps they would have if there wasn't any personal responsibility. So in Singapore, whether the information is held by a government agency, a public agency, or a private company, if you've contacted those organisations, and this is always what the Commissioner says to do first, contact the organisation and see if you can work out a remedy with them directly. If you've done that and you haven't been able to come to some sort of conclusion or any kind of outcome that you're happy with, you can still make a complaint to the Commissioner. The Commissioner can, for private organisations, they can impose fines, they can issue orders, so they do quite frequently. If you've ever got a spare moment and you're interested, their complaints that they consider are all on their site, so you can actually go through and see what they're thinking, which is really good. I like that transparency about it, and it also gives you as an individual a little bit more of a sense of, okay, well, if I were to make a complaint, what would be the likely outcome? What's reasonable? What's not reasonable? So they can take that action against private organisations. Now, the Singaporean government has come out and said that if you've got an issue with public agencies around personal information, biometric data, you can make a complaint to the Commissioner, but practically still wanting to see how that's going to play out, because obviously the Commissioner doesn't have any authority necessarily over those public agencies, but certainly the fact that the government is saying go and talk to the Commissioner suggests that there would be some sort of ability of the Commissioner to at least work with both the agency and the individual in question to find a resolution that works with respect to that personal information. So I think it's good that there is an avenue. There's obviously, because without the commissioner there, as an individual, your rights would probably be limited to bringing commencing proceedings against the public agency themselves, or trying to go to mediation with them, which, that brings us back to that imbalance of power between organisations and individuals. We don't have the resources, we don't have the time, so that's not always an ideal answer. So look, overall, at least on paper, Singapore has a good framework to operate within for individuals to be able to seek redress and to attempt to use that framework to be able to control your biometric data. So it's worthwhile, and I come to this again at the end, get individual, even if you've got a spare 5 minutes, have a look at the PDPC's website. There's a lot of information on there. There's great things about what your rights are. There's some template letters. So they want to help you with this. It's recognised that it's a fundamentally important area of the law, and there are provisions in there. So it's worth no one's going to expect you to be a lawyer on this, but at least if you're aware to say, oh, hang on, that organisation took my information, it appears like they're still using it, and I haven't bought anything off them for years, or they're selling my data when they told me that they weren't going to be selling my data. That gives you those avenues, to do something about it and to bring some of the power back to you. So moving along, we are going to India. Now, India is quite fascinating because, as most of you will know, it's also the government itself is one of the, I think, has the largest database in the world of biometric data, and they use it a lot as part of their system of laws and a way to provide people with government services. So it's a very fundamentally interesting place to have a look at personal information as well, because we also have to acknowledge that in a lot of countries this whole concept of a right to privacy is a relatively new concept. It's not something that's been there for a long time, and historically India has been one of those countries, and China is too, that they haven't had comprehensive data protection or privacy legislation. India has relied on the Information Technology Act of 2000 and the Information Technology, and bear with me, Reasonable Security Practices, Procedures and Sensitive Personal Information or Personal Data or Information of 2011, those rules. So they're kind of collectively called the IT Act and the IT rules, thankfully. Wouldn't want to read that out every time. And so they're the things that have tended to govern data protection and privacy in India, but it's probably really more data protection, and I think we tend to use data protection and privacy interchangeably, but they're not always interchangeable. They do, fundamentally different areas, really. And it's been recognised that the IT Act and the IT rules have had significant limitations. Again, they're not specifically designed for privacy. They were designed for data. As their name suggests, they've come out of IT legislation, not privacy, not this sort of, fundamental human right that's, if you look at where the GDPR has come from, the EU, the European Union enshrined privacy as a fundamental human right, I think back in the 50s. So this is a different world that we're operating in here. So the IT Act, IT rules, not specifically designed for privacy. The scope and applicability of it is very narrow. It only applies to private organisations to which you've got a contractual arrangement with them. So if they're collecting your data without a contractual arrangement, the law doesn't apply. It also is very clear that it doesn't apply to any kind of government or state agencies that are using information. However, India is changing though. So in 2017, there was a landmark judgment in the Supreme Court of India where the court actually held that the right to privacy is a fundamental right under the Indian constitution, and because it was considered a part of the right to life and the right to personal liberty. So in Justice K.S. Puttaswamy and others and the Union of India in 2017, the court actually stated that every person should have the right to control commercial use of their identity, and that the right of individuals to exclusively commercially exploit their identity and personal information, to control the information that is available about them on the internet, and to disseminate certain personal information for limited purposes, actually emanate from that right to privacy. So that was that was a landmark case. That was the first time, this has been recognised as a fundamental human right in India. And that was, quite a significant change in thinking. But because the court was looking at it from the concept of the Indian constitution, what they said was that fundamental right is only enforceable against the government and government instrumentalities. They actually said, look, in order for private organisations to be bound by this right to privacy and this fundamental human right, there needed to be legislation involved. So the government needed to take the fact that the court had decided that there was a right to privacy in the Indian constitution and then translate that into laws that would apply to private organisations. So as a result, that precipitated the Personal Data Protection Bill, which came out at the end of last year, December 2019. It was supposed to be passed this year. #COVID. I think it's still going through. When it does eventually get passed, it'll then be implemented in a phased manner. But basically, the new bill will establish a data protection authority in India, have broad reach, including to persons who are based outside of India but who are doing business in India. It will set out the principles for processing personal information. It will require consent for collection. And it also specifies biometric data as a type of sensitive information. And what that will mean is that there is a higher threshold required for biometric data because it is considered sensitive information. So that will have more onerous consent requirements. I think it'll require affirmative action to consent to giving your biometric data. There'll obviously be tighter controls on storage, how it's used and how it's disclosed, which I think is a great step forward. Then they also have concluded in the new bill this right to be forgotten. So there will be, assuming it goes through in its current form, there will be express rights for data subjects to actually restrict the ongoing use or disclosure of personal information, which would include that biometric information. However, it's not all rainbows and sunshine. There are many exemptions, and I think we need to be really aware of that. It doesn't apply to anonymised data. So coming back to what I was saying earlier, there's some issues with this disconnect between biometric data and anonymisation. The government has also included obviously exemptions for themselves, so they can process personal information and biometric data for reasons such as law enforcement and national security. Now obviously the government's deciding what national security and law enforcement are, which would then govern how they use it. So one would assume that that's possibly a mechanism that can be used to enable the government to undertake actions that they see fit. So still a bit of a wait and see on India in that respect. So if we move into China, China is yet another patchwork of laws, rules, regulations, guidance notes. It's very fractured, the law around privacy. Private organizations are governed by a number of different things. So you've got the cybersecurity law, there's an e-commerce law, there's the information security technology personal information security specification, there's a 2018 version, and I think they're in the process of finalizing a 2020 version. And whilst the law is binding, the specifications aren't binding, but the specifications are seen as highly persuasive. So there's it's quite a jungle to navigate. And I don't propose to go through it all in this talk because we don't have a lot of time to talk about it in detail. And if you do any reading on the Chinese privacy laws, you'll see that there are multiple different topic areas, and there are different laws in different sectors. There's no overarching supervisory authority. So the thing to really be aware of in China is because you don't have one overarching piece of legislation, you don't have one overarching privacy commissioner, it's really a matter of understanding what is the organization that is collecting my data? Do they fall within a particular regulated sector? So network operators are, internet operators are governed by the Cyberspace Administration of China. So you can use them in some instances, but again, they're very narrow and quite complex to try to navigate. There are certain guidelines that do deal with biometric data, per se, and they do call it out as being sensitive data, and then requiring additional controls around the collection, consent, storage, dissemination, all those types of things. But again, that's not in the law necessarily. These are contained in other guidelines that are handed down by various organizations and bodies. The cybersecurity law that I was just talking about that sort of applies to internet operators, that does have a right to be forgotten, but only to the extent that a network operator is in violation of the law or of your agreement with them. So you can go to them and say, well, hang on, you said that you're only going to use this for X, Y, and Z, and you've now used it for A. But that's the only time you can really ask for that right to be forgotten or the right for your data to be deleted. So if they've done exactly what they said they were going to do, there's no real avenues for that. So I think, to be fair, overall the current laws in China don't provide a great deal of protection from an individual perspective. No supervisory authority. There's very little in the way of significant punishment for any breaches of the laws, and the courts have been quite inconsistent in their findings around privacy cases. So whilst there are moves to make, for China to make changes to their various laws, so I think that there's new civil codes that are looking to enshrine some of the rights to privacy and also the right for your information to be protected. There's also a new data security law that's being considered, but it's not clear on the face of it how that would interact with any personal information, because it seems more focused at tech companies collecting data. So there's still a few inconsistencies that make it quite a complicated patchwork to try to navigate. And obviously one of the big issues, or I suppose flaws in any of this legislation, is that by and large the government isn't subject to any regulations when it comes to the collection of biometric data. So it's another wait and see. So what does all of this mean for us as individuals? What can we do? I know, I feel like I've just painted a hopeless picture for some jurisdictions. But I guess what I wanted to come to just in the last few minutes of this talk is what I see as the actions that us as individuals can take, and what are some of the things that are within our control. So, and when I was researching, I found this great quote, and I just wanted to, I can't even pretend it's mine. I think it's exactly what I want to say, which is that rather than relying on companies to safeguard our data or on governments to regulate its use, it's incumbent on each of us to question the steady trickle of our biological information into the hands of profit-led corporations. And I'm as guilty as everyone, so, no judgment here. But, so what can you do? And these are some of the things that I've started to implement since I've really become aware of just how much biometric data is being collected. So really think about who's collecting your biometric data. What are they going to take it for? Read their privacy policy. I know, not sexy, not cool. No one's going to want to sit with me at the bar after this having, said, yeah, let's go read privacy policies. And you don't even need to read all of it. Just read the section that talks about we're collecting your information for whatever the purpose may be. We are going to use it to do this, and these are the people we're going to disclose it to. And really, depending on what the information is, it should be saying we're not going to disclose it to anyone other than our organization. And this is also where concealed data practices start to come in, because when you read privacy policies, you'll start to see that what people will do is say, we will provide your information to any third party that we feel is necessary to know. Or even we'll just provide it to any third party that provides us with services. I mean, that's incredibly broad. Who knows how far that could extend to? So just have a look at that, make sure you're comfortable with what they're going to do with your data, and just take a little mental note of who the privacy officer is and how you can contact them if you need to do something. It's useful to know. Not everyone will have a privacy policy, and it's certainly not legislated everywhere, but it's just something, as I said, skip the start, skip the end, just look at the important bit in the middle. And then use that to assess whether what you're getting in return, the services you're getting in return, the goods you're getting in return, the joy you're getting in return, is worth the potential that you're about to give your facial recognition, your face, photos of your face to other organizations. So look, it's not always possible to find an alternate solution or find one that doesn't require you giving out heaps of personal information. But it's just sometimes having that awareness of like, okay, is the amount of data I'm giving them really worthwhile to me? Am I getting something in return for which I'm comfortable? And I'm comfortable that the organization I'm giving my information to is going to control it. They're going to use it carefully. They're going to do what they say they're going to do. And if they don't, I know exactly what my what my recourse is for that. I know what I can do about it. So as I said, right to be forgotten, I'm a big advocate for this. I really do think that we should be looking at our privacy laws, get more prescriptive laws in place, but that's probably another talk for another day. And as I said, it's probably something we think of less, but this whole idea around our elected representatives. Start to look at what your MPs, your members of parliament, start to have a look at what your government representatives are doing, your elected representatives. Do they have thoughts on privacy? Do they align with your views on privacy? There's a whole lot of things that go into our voting decisions, but I think that should be one that we start to really look at, is like, do the elected representatives align with my thinking on how important my personal information is? And because I do think there is this world where we need to balance this disconnect between the rights of individuals and the power of organizations. And the people that can do that, the people that can shift that balance is our government. So I think the democratic process can be quite important in this, even though it's the long game. There's no immediate gratification here. And then obviously the last one is where there are regulators or supervisory authorities that are in place, use the resources that they have available to you, because they're also in that role of trying to shift the balance as well. And they're trying to make that a bit more of a level playing field. So I guess the final note, and thank you so much for spending this time with me, I really appreciate it, but my final thought on this is just empower yourself. Know what you're willing to share, know what you're willing to do to protect your personal information. Thank you so much.